Salutations, respected viewers. This is George from Ireland. I'm continuing my series on English law, talking about criminal law. I'm continuing my fictive case of Terence, the chap who was charged with burglary. So I had him being sent to prison, and he has the chance to appeal, but he chooses not to. That would simply delay things. He's got a 12-week sentence, and he's going to be released after only 3 weeks, so he just doesn't bother. And this is typical in the cases of very short sentences. People only cool their heels in jail for a brief period, and they're usually released after just a fraction of that has passed. Sentences tend not to ever get shorter than 12 weeks. And if you're only going to spend 3 weeks incarcerated, is there any purpose in locking the person up at all? Some people say, let's not bang them up. There we are. So Terence now has a criminal record, but as he works as a builder, the sentence shan't be an obstacle to him finding work in future, because some jobs can ask for a basic disclosure, but most jobs are not allowed to ask for an enhanced disclosure. So if you work with minors in any capacity, including being in the police or anything like that, or if you work in financial services, it has to be a basic disclosure. And no matter what you did, no matter how long ago, even if you only got a caution for it, not a punishment, that will always be declared. Indeed, there can be information disclosed at the Chief Constable's discretion. The police could put something on your enhanced disclosure saying that you were a suspect or whatever, even if you weren't convicted, even if you weren't charged. Now that's unfair, but that is the law. But as he works as a builder, that won't be the case, and they probably won't even ask for a basic disclosure. Convictions after a while are spent, as in if you ask for a basic disclosure on someone, it wouldn't be shown. Quite complex rules about how minor it was and how long ago it was, how long the sentence it was, so that after 10 years it wouldn't be mentioned, something like that. So give people a chance to reform. Otherwise, if they can't get a new job, it's difficult to rehabilitate them. So in basic disclosures, that's the case. In enhanced disclosures, it's never ever wiped. The one thing is, Terence will never be able to become a solicitor or barrister. There's some occupations which are forbidden to you if you have a criminal record. And he would find it all but impossible to work in the financial sector. He wouldn't necessarily be banned from working with minors. I think in the burglary case he would, but if you have a criminal record per se, possession of cannabis, for instance, you would be able to work with minors so long as it's sufficiently long ago. If it was a theft, it was a minor one, like say stealing lipstick, which I know someone did, and she was able to work with children several years later. So Terence can appeal at any point in his life. In practice, they tend to do so pretty soon, or else not at all. If the court finds it's unsafe, the conviction will be overturned, right? Now, in most cases, the court says, no, the correct decision was made, it's upheld, that's it. They deny the appeal, which they say the appeal fails, the conviction still stands. But if they find the conviction to be unsafe, well, there are three things that can possibly happen. They can order a retrial, or they can say, okay, he is now not guilty, that's it. They can find the condition to be unsafe without commenting on whether he's guilty or not, or they can declare it to be unsafe and say he is not guilty. If you found to be not guilty, if they found him to be not guilty, then his record is wiped. The criminal record's gone. I have another case study. Supposing there's a terrorism case. Well, Violent and Will are arrested on suspicion of conspiracy to cause an explosion with intent to endanger life. The police go through the normal procedures at a police station. They're fingerprinted, DNA is taken, they're separated, different cells. You'd always be in separate cells. Even if you're sharing a cell, men and women would be in different ones. The personal effects are confiscated. Solicitors are brought in, and the two suspects are questioned separately. They're not allowed to have any communication. Obviously, their phones have been taken. The solicitors advise their clients not to say anything unless they absolutely have to. That's another point. Margaret Thatcher said this as she was a barrister. Don't admit more than you really need to. If in doubt, don't say it, because it's very difficult to retract it later. The police questioned the pair for 2 days. Because they're arrested under the Terrorism Act, they're allowed to hold them for up to 28 days without charge. After 28 days, either charge with the crime, and you could have them remanded in custody, wait their trial in prison, or they have to be released after 28 days because you're not charged with anything. So ordinary crimes is 24 hours. If it's in relation to terrorism, it's 28 days. The Labour government, they wanted it to go up to 90 days. Some people were even saying it should be without limit, as long as it takes. because of the more complex nature of gathering evidence from the internet in other countries. Anyway, the police tell Will that Violet has cracked under questioning and has spilled the beans. And as she's told all, you might as well fess up. We found your fingerprints in the explosives as well. In fact, these statements by the police are bogus. The solicitor counsels Will not to answer further questions. However, Will decides to go against the solicitor's advice. The advice is just that, it's advice. It's not an order. Will can do what he wants. He panics and confesses that he plotted to set off a bomb. Violet refuses to cooperate with the police. The police then charge both of the crime. Will then tells the solicitor he committed the crime, but has changed his mind and wishes to withdraw his confession. The solicitor says that as Will has told her that he did the crime, she will not defend him on the basis that Will is innocent. She is willing to defend him by pleading mitigation, that he's remorseful, he did it, and he was furious, but he's otherwise a good person. However, the solicitor refuses to lie for Will. If he wants to commit perjury in court, the solicitor will resile herself from the case. She'll resign as his legal counsel. In which case, Will can get a different solicitor who is not asked to lie for him. Will changes his mind, decides he's going to stick to his confession. Right, so they're kept in. There's a bail hearing the next day. Can they go home, await trial at home? The police oppose bail because the two were charged with a heinous offence. There's a flight risk, as in danger they run away. Moreover, Will is previously known to the police, has been a suspect before, and he's been convicted for supplying drugs. The two are remanded in custody. This means they await trial in prison. As they're remand prisoners, they're permitted to wear their own clothes. Incidentally, if you appear in court in England and Wales, the defendant, you're allowed to wear your own clothes. A suit in America, you have to wear a jumpsuit and handcuffs, so you look guilty, prejudices the jury against you. The trial commences after a month. Violet pleads not guilty. Will pleads guilty. The trial takes a further month. There's a jury, because this is in the Crown Court, and they're facing a long sentence if found guilty. Violet is found not guilty, and she is set at liberty. Will is found guilty. In view of his early guilty plea, he's sentenced to only 10 years in prison. If he pleaded not guilty and been convicted, he would have got 15 years. He then asks for leave to appeal, as in permission to appeal. It's granted. He appeals on the basis of the facts. He says the information presented to the court was wrong. A new judge hears the case. As she was not the judge in the original trial, she decides the appeal is false, and she upholds the appeal. The conviction. So she denies the appeal. You're still guilty. The original court got the right decision. You're staying in prison. A few years after that, Will appeals again. So there's another judge. Will says that the judge of the original trial erred in law. So a judge is hearing the appeal, and the appeal is ongoing when Will comes up for parole. He decides to end his appeal because if your appeal is ongoing, you can't get parole. He wants to get out on parole. There must be no outstanding appeals. He then goes before the parole board, and he convinces them that he's truly sorry for his crime. He's a genuinely reformed character, and he is safe to release. Well, so first of all, they give him day release. He's allowed out for 12 hours to assist his wedding, then get back to prison. So that he's on time. So when his grandmother dies the next month, he's allowed out for 12 hours for the funeral. And then he goes back to prison. 2 months later, they allow him to start working on a farm for 6 hours a day outside prison. This carries on for a year. Then they allow him out for a weekend. And the next month, he gets another weekend. And the next month, he gets a week out. He always returns on time. If he was late, then he wouldn't be allowed out for a long time. So he's being prepared for freedom with taste of freedom. It's also a way to control his behaviour, because if he is bad in prison, they will no longer give him day release. He's released on licence after 6 years. He's on a tag. So on licence, at any point, the authorities could send him back to prison. It's just an administrative process. There doesn't have to be a judicial hearing, because really he doesn't have the right to freedom. They're doing him a favour by allowing him freedom at that stage. He has to report to a probation officer weekly and say what he's been doing. He's living in a halfway house with other ex-cons. So the police suspect he's up to no good. They can put him back into the slammer for the remainder of his sentence. After a year, probation is over and he is free. So that's an example of how these cases would work.